left and right tonight, we've been talking about how Donald Trump is breaking away from presidential norms. So here is another example, which I have in front of me. These are the letters from the Attorney General of the United States to Apple and a variety of other companies, Amazon, Google and the like, in which Pam Bondi told tech companies they would not be held liable for breaking the so-called TikTok law. It prohibits them from working with TikTok. And what, of course, the letters say is it's raised concerns amongst legal experts. It says that according to the president, there's been no violation of the statute and there is no liability from conducting a behavior with them. Zachary Price is with me, law professor at University of California, UC San Francisco. He joins me now. This is basically saying, well, the president has said the law's not being broken, therefore, sorry, the president has said you can do what you like because he doesn't think the law is valid anyway, and that's the end of that. This is a highly, highly unusual step.
Yes, I agree. Thanks for having me. I think the fundamental problem is that the president is claiming a power to cancel the effect of a statute, and the Constitution, to the contrary, says the president shall take care that the laws be faithfully executed. So it's a direct contradiction of what the Constitution requires from him.
But the world is replete with prosecutorial discretion, where the prosecutors may decide it's not worth prosecuting, or the prosecutors may decide on public policy grounds that they're not going to. Why is that different here?
Yes, so that's a great question. Executive officials do generally have prosecutorial discretion, but what that means is that they can choose to pursue one case rather than another, or even set general priorities for enforcement. But nonetheless, what they can't do is change the law itself. We have seen a number of controversies in recent years about where to draw that line, but I think however you draw it, this policy goes beyond what's allowed.
This idea that basically because the president says, they've dressed it up quite nicely by talking about responsibility under Article 2 of national security and conduct of foreign policy. So in essence, what they're doing is, what the AG is doing is bringing it in, this is part of his official responsibilities as president under the Constitution. Therefore, it's back to the Supreme Court's decision, isn't it? That a version of the king can do no wrong, the president can do no wrong when it's vis-a-vis his official duties.
Yes, so it's true that foreign affairs, national security are generally thought to be areas of special presidential responsibility. The trouble with that argument here is that Congress also has powers in those areas. It has explicit power to regulate commerce with foreign nations. It passes laws all the time in matters affecting national security. And so there's not a good argument this law is unconstitutional. So really the president is claiming a power, again, to just suspend a duly enacted law.
How far is that decision of the Supreme Court a few years ago, that basically the president is immune, absolutely immune for areas within his purview, and presumptively immune on official grounds? You've got to go pretty far down the ladder before you get to sort of personal acts.
Yeah, so that decision did recognize this presidential immunity. It's in some ways a quite confusing decision and not clear how far it extends. I think it can be read narrowly. But I think an important thing here with the TikTok issue is that companies are relying on these presidential assurances, but as we were discussing, the assurances are unlawful. And I think if in the future, say a future president were to seek penalties against them, I don't think the presidential statements would give them any sort of defense.
Professor, I'm grateful. Thank you, sir.